today's webinar, Understanding Trademarks, which is a part of our series, Getting Started with IP. My name is Fasiha, and I work in CIPO's Business Services branch in the Intellectual Property Awareness and Education team. Today, we are going to cover the basics of trademarks, and by the end, you should have a clear understanding of what trademarks are and how they work. Before we talk about trademarks, let's take a moment to look at what the Canadian Intellectual Property Office, or CIPO, does. IP stands for Intellectual Property. IP rights are territorial and are managed by the IP offices of countries around the world. In Canada, it's us, CIPO, that is responsible for the administration of most Canadian IP rights. CIPO is part of the Government Department for Innovation, Science and Economic Development Canada, and we handle application guidelines, forms, and examinations used in the process to issue patents, trademarks, and industrial designs. We also work on increasing IP awareness among Canadians. So, CIPO is a national IP office representing Canada, and the IP rights granted by the office provide protection across the country. As I mentioned before, we work to raise awareness for the effective use of IP by Canadians. To this end, our IP awareness and education program delivers a wide range of products and services, free of charge, to help Canadians better understand the importance of protecting and managing their IP assets. We are a team of content writers, presenters, and IP advisors who can assist innovators, creators, and entrepreneurs in understanding their IP before engaging in discussions with IP professionals or lawyers, where, of course, IP will become a central point of the conversation. Therefore, we have the resources to explain what IP is, how you can identify your IP, how you can protect your IP, how you can manage it, and where to find help. Our tools and resources are available on our website, and we also offer fact sheets, detailed guides, online learning modules, roadmaps, and more to explain the steps to register for formal IP rights, of course, including the roadmap for trademarks, which you'll find relevant after today's presentation. We also organize seminars and webinars and offer free meetings with our IP advisors both online and in person. Now let's start with an overview of what intellectual property actually is. IP comes from a creation of the mind. You might hear that ideas are protected as IP, but it is indeed the form an idea takes when created that can be protected. A few examples of intellectual property include brands, logos, inventions, original artistic works, and the visual appeal of designs, as well as secret recipes or formulas. So IP really is everywhere. It's literally all around us. We find that most businesses have some form of IP, whether it's formally protected or not. In business, IP can set one's goods or services apart from others, and IP is sometimes referred to as property because, just like real property, rights are acquired with ownership. Like when you own a building or land, you can sell it or lease it and keep others from trespassing into your space. It's the same with IP. You can sell or license it and exclude others from using it. As well, like real property, IP is a valuable business asset. IP rights encourage innovation by giving creators the exclusive right to prevent others from stealing or appropriating their innovations. Here you see traditional types of IP and the registered rights that are associated with them. Of course, there are trademarks, and we will talk about them extensively throughout this presentation, but we also have patents, which refer to the functionality and offer technical solutions to any given problem. Patents protect new or improved products, machines, processes, and compositions, and the invention to be protected has to be new to the world, useful, and inventive. There are also copyrights, which refer to the exclusive right to produce, reproduce, publish, or perform an original work of literary, artistic, dramatic, or musical nature. We also have industrial design rights, which, on the other hand, concern the appearance of an object. They serve to protect solely the aesthetic appearance of a product. So this refers to whatever appeals to the eye and includes unique shapes, patterns in clothing, fashion, accessories, technological devices, and the list goes on. Finally, we have plant breeders' rights, which protect the varieties and denominations of new plants. However, these are not managed by CIPO and are indeed handled by the Canadian Food Inspection Agency. There are also other types of IP that cannot be formally protected but still hold important value. One such example is a trade secret. A trade secret refers to any business information that derives its value from its secrecy. It can be a method, technique, a proprietary know-how, a formula, recipe, or more. And trade secrets can be extremely valuable, whether you have developed new technology, crafted the perfect recipe, or put together a gold mine of customer data. However, it may not be the best choice of IP protection if your competitors can easily reconstruct your creation because, as mentioned, it cannot be formally protected, and the only way it can retain its value is by maintaining the secrecy around it. Some other examples of non-traditional IP can include domain names and websites, which are not the same as trademarks, as domain names refer to the addresses on the internet where users can find you and are operated by private companies. Trademarks are used to identify and distinguish one's goods or services in the marketplace and are registered through national IP offices. As well, social media accounts are a form of non-traditional IP as they contain a ton of IP, including trademarks and copyrights. More non-traditional IP can include customer lists and publicity rights, which deal with the individual's right to control the exploitation of their own image. So now that you have a deeper understanding of what intellectual property is, the objective today is to give you a deeper understanding of what trademarks are. And today we'll be answering the following questions. What is a trademark? Should I register my trademark? How to choose goods and services associated with a trademark? The different criteria to consider when creating a trademark. More importantly, how much does this process cost? How long does it take? And perhaps what is most sought after, who can help me with this process? Let's start off with looking at what a trademark is. A trademark is a sign or combination of signs used or proposed to be used by a person to distinguish their goods or services from those of others. So a trademark is very important to a company because over time, a trademark comes to stand not only for the actual goods and services you sell, but also for the company's reputation and overall brand. For example, when a consumer sees a Coca-Cola bottle of soda, they do not believe that they are buying Pepsi or a store brand soda. They know that they are buying Coca-Cola. And similarly, when somebody sees the shape of a Toblerone bar, they don't think they're buying any chocolate bar. They know that they are buying the triangle-shaped Toblerone chocolate bar. And when a consumer buys an electronic product with an Apple on it, they don't believe they're buying a Samsung device. They know that they are purchasing an Apple device. So these words, designs, and shapes are all trademarks, and they are all used to distinguish one set of products and services from another. So in essence, trademarks are truly all around us. In fact, according to the International Trademark Association, the average person sees more than 1,500 trademarks in a day. Just think about that. When we wake up in the morning and have a shower and brush our teeth, we may use Pantene shampoo and Dove conditioner. And when we sit down to have breakfast, we may have Cheerios in a bowl of Natrel milk. And we might start our day with a Tim Hortons coffee made in our Nespresso coffee machine. We haven't even gotten dressed yet, and we've already seen 6 trademarks. A trademark registration gives you the exclusive right to use the mark across Canada in association with your goods or services for at least 10 years. You can then renew your rights every 10 years. Before going further, let's see if you can identify the following brands. So, when you look at this image, what comes to mind? Of course, this represents the Pringles brand. And similarly, when you look at this image, what comes to mind? Well, this represents Starbucks. And of course, when you think of this dark blue for social media, what platform do you associate it with? Facebook. And if I show you the color red on these shoe soles, what do you associate it with? In this case, the trademark is actually the red color that's applied to the sole of the shoe, and the rest of the shoe is not a part of the trademark. And indeed, it belongs to the French designer Christian Louboutin. So in conclusion, these examples demonstrate just how strong a brand can be. When consumers recognize a brand just by looking to a design or a color without any reference, it truly shows the power of trademarks. Now, there are several different types of trademarks. First, we have standard characters and designs, which refer to words and designs and can include logos and slogans. So perhaps we can think of Tim Hortons and their word mark and their design mark as shown on the screen here. And we can also think of Canadian Tire and their word mark and their design mark, and then a combined word and design mark with both their logo and their name. Trademark in standard character can be a combination of letters, numbers, and symbols without any claim to a particular font, size, or color. And once it's registered, the owner of the mark in standard characters can use the mark in any way that they desire. If the trademark, however, is registered in a special font, color, or with a design, or it's consistent of another design, it will have to be used as registered. And looking at other types of trademarks, we have non-traditional trademarks, and since June 17th, 2019, elements like tastes, textures, moving images, modes of packaging, holograms, sounds, scents, three-dimensional shapes, colors, or even a combination of these can be registered as trademarks. Some examples include the cell phone adapter from Apple, the three-dimensional shape of a Coca-Cola bottle, the roar sound of the MGM lion is incredibly recognizable as we hear it probably at the start of some of our favorite films. Also, the numbers you see at the screen are actually registration numbers. Your trademark will have 2 numbers associated with it throughout its lifetime. The first will be an application number, and once the trademark is fully registered, it will have a registration number. You can use these numbers to search for your trademark on the Canadian Trademark Database. You might have also heard that there is no need to register a trademark and that simply using it in trade provides the same protection. This is not entirely true. It is true that registering your trademark is not mandatory and that you can pick a trademark and start using it without having it registered and still get the same level of protection, but we still encourage you to register your trademark. And why is that, you may ask? Well, when you register your trademark, you get the sole right to use the mark across Canada as long as you use the mark with the associated goods or services and can maintain it every 10 years by paying the required fee. Also, once you receive the certificate of registration, the certificate is direct formal evidence that you own the trademark. This makes the enforcement of your trademark a lot easier. And if you have the exclusive rights to it, you can prevent others from using it. You choose to sell it, license it, or trade it, and if you don't register your trademark, you can still enjoy these certain rights under common law. For example, you will likely have protection for the trademarks that you use with your goods or services in the region in which you use them rather than the entire country, as is the case for most registered trademarks. Another aspect that you will have to consider if you choose to not register your trademark is the effort that may be involved in defending your trademark rights. So having a trademark registration is direct proof of ownership of the mark and the duration for which it has been registered and used. Without this registration, these aspects would be more challenging to prove and indeed more time-consuming and costly. And of course, once a trademark is registered, it is entered in the Register of Trademarks, which means that it will be a part of the search for confusion by other marks owners, which is a great way to find out if identical or similar marks are already used for other similar goods or services within Canada. Now, moving into the application portion of a trademark, it must include a list of all the goods or services for which a person or company uses or plans to use the trademark for. all goods or services on that list must consist of terms used in the trade and be grouped and classified according to the NICE classification. So let's break down what that means. When we refer to terms used in the trade, we are talking about the fact that these terms have to be in a language used by others within the same industry to describe the goods or services. For instance, skis are defined in the Oxford Dictionary as one of a pair of long, narrow pieces of wood, metal, or plastic that you attach to boots so that you can move smoothly over snow. Now, we understand what it means and wouldn't necessarily need this statement as part of a trademark application, but that's not how we refer to skis in the trade. We need to be more specific. So in the case of skis, you would have to indicate the specific type of skis in the application for registration. So are they alpine, cross-country, roller, snow, surf, water, etc.? To help you compile your list of goods and services, you can use CIPO's searchable database available online called the Goods and Services Manual, which we will include in the final links at the end of this presentation. This manual contains goods and services statements used in the trade. All terms found in this manual are pre-approved by CIPO and will be accepted if they are included in your application. And as we saw, goods and services are grouped according to the NICE classification. What exactly is that? The NICE classification is an international classification that groups goods or services into 34 different classes of goods and 11 different classes of services according to the fields in which they belong. So going back to our example of skis, they would belong in class 28 with other sports articles. However, ski wear would belong to class 25. That is often the biggest point of confusion for clients in concluding what class their product or service belongs in. And the answer to that, as mentioned before, can usually and quite easily be found in CIPO's Goods and Services Manual. Let's now examine the criteria that your trademark needs to respect in order to be eligible for registration in Canada. The most important of all is that your trademark should be distinctive, meaning that your trademark should have a certain degree of distinctiveness to it. The Collins English Dictionary defines distinctive as something that has a special quality or feature that makes it recognizable and different from other things of the same type. So if we consider this definition in the context of trademarks, we could say that a distinctive mark must be recognizable and different from other trademarks on the market for similar goods or services. And the strongest trademarks are often the least descriptive but the most distinctive. They are fanciful and arbitrary, and they usually include made-up words. And they also include ordinary words that are not directly associated to the product or the service offered. So with this last point, what exactly does it mean? Let's take a look at an example to help demonstrate further. So on the screen, we see 3 different trademarks. We see Nike for sneakers, an image of boots for sports, and Puma for the retail sale of footwear. So, considering this list of goods, which of the following trademarks is not distinctive? So, of course, as I mentioned before, a distinctive trademark refers to ordinary words that are not directly associated to the product or service offered. In this case, the trademark is a design representing alpine ski boots, and the statement of goods is boots for sports. So, in this case, the trademark describes the goods, being boots, quite clearly. Nike and Puma, on the other hand, have no meaning associated to the good sneakers and for the retail of footwear, and so they are considered good trademarks. Continuing on with the criteria required to register a trademark may not be registered if it contains a name or a surname. So names and surnames are often shared by individuals or families, and allowing individuals to register them as trademarks could create confusion and conflict within existing trademarks and could give those individuals an unfair advantage over others who share the same name or surname. So names and surnames are not typically eligible for trademark protection because they are not considered distinctive enough to serve as indicators of the source or origin of goods or services on the marketplace. It would, of course, be unfair to allow one business to have the exclusive right of a name or a surname. However, there are some exceptions. If the distinctiveness of the name can be shown, if it can be proven that your goods or services have become well known under a specific name or surname, so that the word has acquired a secondary meaning in the public mind, then it could be considered acceptable. And a few great examples of this include Ralph Lauren and Tim Hortons. Continuing further with the criteria needed to register a trademark may not be registered if it clearly describes the character or quality of your goods and services. So, for example, the words sweet for ice cream, juicy for apples, and perfectly clean for dry cleaner services could not be registered as trademarks. All apples could be considered juicy and all ice cream could be considered sweet. These are natural characteristics of the items, and if you were allowed to register these words, no other apple sellers or ice cream vendors could use them to promote their goods, and that would of course be unfair. So all traders should have the right to use apt descriptive language in order to register their trademarks. As well, a trademark is not registerable if it is the name of the goods or services in another language with which the mark will be used. So one business cannot have the monopoly on words used to explain to consumers what the business does or sells. For example, you would not be able to register the word gelato, which is Italian for ice cream in association with frozen confections. And most importantly, one trademark can't be confusing with another trademark being too similar. A trademark may not be registerable if a consumer could easily mistake one mark for the other and believe that the goods or services come from the same source. So in other words, when consumers see a product or a service with a trademark that is similar to another one that they are familiar with, they may mistakenly believe that the two are related or produced by the same company. This, of course, can be quite harmful to the owners of the original trademark, as it can dilute the distinctiveness of their brand and cause them to lose customers. So, what do trademark examiners look at when deciding if these trademarks could be considered confusing? Two trademarks coming from different owners could be considered confusing if they look or sound alike, if they suggest similar ideas, and if they are being used to market similar goods or services. So, for example, if you want to register the mark North Pole for ice cream, and suppose there is another company that's manufacturing and selling frozen water products under the registered trademark South Pole, the public could easily think that North Pole and South Pole products are made and sold by the same company and may expect the trademarks would be owned by the same organization. That could mean your application to register North Pole would be turned down because it could ultimately cause confusion with the registered mark South Pole, which would be registered and owned by another company. Of course, there is an exception to having similar or identical trademarks if they are not in the same range of products and services. This means that you can have the trademark Barbie for dolls and the trademark Barbies in relation to restaurant services. That's because the public is not likely to be confused by those two trademarks. They're clearly in different markets. Continuing on with the criteria needed to register a trademark, you may not register a trademark that describes the geographical location where the goods and services come from. Allowing you to use regional names as your trademark would mean that you are the only one who can use that regional place name, and of course that would be unfair to those who trade in that place. So, for instance, you could not register Italy for lasagna. Also, you cannot register a deceptively misdescriptive trademark. For example, you can't register cane sugar for candy sweetened with artificial sweetener, or Air Express for a courier service that uses ground transportation. You may also not register a trademark that is identical or similar to certain official marks unless you have the permission from those organizations that control the actual marks. So, what exactly are official marks? By definition, an official mark is a form of intellectual property that exists in Canada and allows the protection of names or designs used by public authorities such as the government, regional municipalities, federal agencies, universities, etc. And these official marks include flags and symbols of other countries, coats of arms of the royal family, flags and symbols of the other countries, emblems and names of the Red Cross, the Red Crescent, and the United Nations, as well as armorial bearings or coats of arms for symbols of provinces, municipalities, and public institutions. In summary, before creating your trademark, ensure that you go through this entire list and choose a trademark that will be distinctive and respect these criteria. So your trademark should not include a name or a surname. It should not be descriptive. It should not have the name of goods or services in another language. It should not be confusing with another mark. It should also not be descriptive of a geographical location. It should not be descriptively misdescriptive, and it should not be identical or likely to be mistaken with an official mark. Now, let's try to put the theory into practice and have a look at a few examples. So, why would this mark not be registerable? We have on the screen genuine leather with the statement saying for leather boots. Of course, the trademark genuine leather is clearly descriptive. That's why it could not be registered. This mark explicitly describes the nature of the boots, namely that they are made of genuine leather. If the genuine leather trademark, however, was used with vegan leather boots, the brand would still not be able to register as it would be deceptively misdescribing the trademark, meaning it would inaccurately describe a characteristic or a quality of the boots, leading it to not be registerable. Moving on, when you look at Foot Locker and Boot Locker, would these two marks for the sale of footwear be considered confusing? They would probably be considered confusing in the examination by a trademark examiner, as both marks are in the same font, they use mostly the same colors, and really the only difference is the letters F and B and a slight change in the color. So we can easily imagine that a consumer on first impression with perhaps imperfect recollection could think that both trademarks are from the same owner. So a trademark has to be distinctive, easily recognizable, and different from other trademarks for similar goods or services. And to avoid choosing a mark that would be confusing with other trademarks and make sure that you are not infringing on anybody else's trademark, you can search the Canadian Trademarks database, in which you'll find all registered trademarks and pending applications within Canada. Please note that, as we mentioned before, trademark protection is on a national basis, meaning that you should search international databases if you are thinking of using your mark abroad. Trademark applications and registrations are public records, so individuals and private companies and anybody in general should have access to trademark-related information through the Canadian Trademarks database. Now, let's have a look at the trademark registration process. We start off with the application being received by the office, and then the application is formalized. It's at this step that your application receives a filing date. Then the file will be examined by a trademark examiner. It's at this step that the trademark is being searched for confusion with other trademarks. If there are any issues with your application, as confusion, for example, you will receive a report and will have 6 months to respond. Otherwise, the trademark application will be abandoned. After your file is approved, it will be published in the Trademarks Journal, which is noted in the step called Advertised in this IP Roadmap, for a period of 2 months, and will give the opportunity to others to oppose your application. If there is no opposition to your application, or if an opposition is rejected, your application will proceed to registration, at which point CIPO will send you a certificate of registration and enter the trademark in the Register of Trademarks. It's also important to note that there is a significant waiting period between filing and examination, but if you use the pre-approved list of terms in the Goods and Services Manual on CIPO's website, you could complete the registration process in about 1.5 years, if nothing goes wrong, in comparison with a little over 4 years if the pre-approved terms from the Goods and Services Manual were not used. All in all, you can expect to have your trademark registration completed approximately between 1.5 to 4 years. It could be more if you encounter challenges during the registration process, but that is the general timeline for it. Now, let's take a look at how much it costs to obtain and maintain a trademark within Canada. In 2023, the application filing fee for a trademark is $347.35. This amount includes the first NIS class of goods or services, and the fee for each additional NIS class of goods or services is $105.26. To maintain your trademark registration every 10 years, you have to pay a renewal fee of about $421, which includes the first NIS class of goods and services, and $131.58 for each additional NIS class that is added. So let's say you have 3 NIS classes in your application. Filing your trademark would cost you about $558. And to maintain your registration after 10 years, it would cost approximately $684. These fees are for 3 classes of goods and services in an application. The last column on this screen includes the fees that will be in effect starting from January 1st, 2024. You can see that the deposit fees as well as other fees will be increased to $458 and $139 for each additional class. So it takes about $555 to renew your trademark and another $173 for each additional class. Now that we know a bit more about trademarks, let's see what an IP professional could help us with. So an IP professional could help carry out services such as conducting the preliminary research for you and assessing your trademark for registrability. They could also assist you in writing the application with the appropriate technical language. As well, they could help respond to the examiner's reports and amend the application accordingly. And they could also take care of maintaining the registration process overall. It is indicated on screen that the cost for obtaining assistance from a professional ranges between $500 to $2,000. Naturally, these costs can vary considerably. For example, the cost of a preliminary search will be lower if you entrust the entire application to the IP professional you are working with, and it could also depend on the number of NIS classes contained in your application. It is the intellectual property professionals who will provide you with more information on this matter. Now, is having your trademark registered the right decision for you? Let's take a look. First of all, it's important to remember that trademarks can be among the most valuable assets of a business. The point of a trademark is to have an identifier in the marketplace that differentiates your product and services from those of others. By doing this, the business aims to build a reputation, goodwill, and a brand name associated with them and their goods or services. As well, your brand tells your customers what they can expect from your products and services. It allows you to set yourself apart from your competitors and is a true indicator of source. As well, your brand allows you to express what your business stands for, what you want your business to be, and how your business is perceived in the marketplace. Also, when you get to the point where your business expands beyond the local market where you can demonstrate customers identify with your brand, if you haven't registered your trademark yet, it could be a good time to initiate the registration procedures here. It's also important to remember that registration offers a number of key advantages. So you get the sole right to use the mark across Canada for 10 years. Your certificate of registration is a direct piece of evidence of your ownership. It also prevents others from using your trademark without your knowledge. And in the event of litigation, enforcing your right will be less expensive and just easier in general because you own it. So, what should be your next step if you are ready to apply for your trademark? If you're thinking about this, the next thing would be to visit the guide for how to prepare and file. And it's a good idea to consider reaching out to an expert as it can be a challenging process. So overall, what are the key takeaways from today's presentation? The first is that trademarks can be the most valuable assets of a business, and using the Goods and Services Manual can help you save time and accelerate your examination process considerably. Also, it's important to remember that a trademark should be distinctive and should not be only a person's name or surname. It should also not be clearly descriptive or deceptively misdescriptive. As well, it should not be the name of a good or a service in another language or be confused with another mark. It should also not be the geographical location where these goods or services are coming from, and it should not be identical or likely to be mistaken for official marks within Canada. All of the resources, materials, and tools that I have discussed today contain a wealth of useful IP-related content and are available in different formats including audio, video, text, and interactive. Like I said, although we are happy to guide you and give you as much information as possible on IP rights, we cannot provide you with legal advice. All of the questions that you see on this slide are unfortunately questions that require a legal opinion. You might also require help in understanding complex topics, obtaining legal advice in case of infringement, or seeking an opinion on strategic positioning and searching advanced databases. To that effect, there are groups and associations of IP professionals that you could turn to. To locate a licensed IP agent near you, you can contact the College of Patent and Trademark Agents, or CIPO, which is the newly formed organization responsible for the management of IP agents. We recommend that you only deal with IP agents that are on the CIPO list of registered IP agents, and this is because these are individuals that have passed IP-related exams, and they are regulated and disciplined by the CIPO. There are unfortunately individuals out there who will pose as an IP expert while they do not have the required credentials, so it's really important that you stay diligent and that you consult the CIPO website to know that you are hiring the right person to assist you with your IP rights. Of course, the Intellectual Property Institute of Canada, or IPIC, and the Bar Association are professional associations where you can also find lawyers or IP professionals, and just look further for more resources. In summary, the Intellectual Property Awareness and Education Program offers a wide range of tools, services, and resources to assist Canadian small and medium-sized businesses, innovators, and the general public in their IP journeys. Please do not hesitate to contact us if you have any questions or need help finding any of our resources on the website. You can reach us via the contact information you see on your screen. As well, you can contact any of our intellectual property advisors for a more specific and tailored discussion to your needs by scanning the QR code on the screen. I also invite you to follow us on social media. We are on Facebook, YouTube, LinkedIn, and X. This way, you will stay updated on the latest additions to our products and services. So overall, this concludes our webinar for today. I hope you have learned more about trademarks and that you enjoyed this presentation. To learn more about the topics related to intellectual property and to take a look at everything that has been discussed today, I invite you to watch our other videos, and you can also register for live webinars on our website. Thank you so much for watching.